In today's class, we are going to study two very important topics from which UPSC has asked questions not only in the prelims exam but also the main examination. From these topics, UPSC has asked questions not only in the GS paper but also in the optional subject of public administration. The first of these concepts is the concept of judicial review. And the second concept is of judicial activism, which is also sometimes called as judicial overreach. Let me show you a question which UPSC has asked in the optional paper. And from this topic of judicial overreach, questions have been asked in paper 2 of general studies. So let us see today in detail the concepts of judicial review and the concept of judicial activism, or which is also called as judicial overreach and sometimes as judicial adventurism. First, let us look at the concept of judicial review. We understand that India has a written constitution. Not only we have a written constitution, we further have the concept of supremacy of constitution. That means this Indian constitution is considered the fundamental law of the land. The fundamental law of the land. That means apart from this fundamental law, the parliament and the respective state legislatures can enact a lot of other ordinary laws. But in terms of authority, in terms of sanctity, in terms of status, the Constitution of India holds the highest significance. It is the most basic, the most fundamental, and the organic law of the land. All other laws enacted by the parliament or the state legislatures, they have to conform to the Constitution of India. So under this constitution, we have parliament. We also have respective state legislatures who have the power to make a number of laws. And yes, in the last 71 years of the working of this constitution, our parliament and state legislatures have enacted hundreds and thousands of laws. Now, all these laws, law number 1, law number 2, law number 3, and henceforth, all these laws have to be according to the provisions of the Constitution. Only then we can say that the Constitution of India is the supreme law of India and the highest law of India. Only then we can say that India not only has a democratic constitution, but it also has high levels of constitutionalism. Because as Dr. Ambedkar had rightly observed, what is more important is to run and implement a constitution. If this Constitution of India, it fails, it is not the fault of Constitution, but the persons who have the responsibility to implement and run this Constitution. So once we draft a Constitution and we give it the highest status, we have to ensure that all the other laws, all the other policies, all the orders made in the country are according to this supreme law, are according to the provisions of the Constitution. This is ensured by the judiciary of India by the power of judicial review. The concept of judicial review means it's a review of any law, any order made by the parliament or by the executive, the government of India, or even by the president of India. So president of India can make an order, can make an ordinance, can make a proclamation, for example, for emergency. So all these orders, proclamations, ordinances, laws, they have to conform to the provisions of the Constitution. If not, then they can be declared as null and void, as ultra vires by the judiciary. This power is called as power of judicial review. That means if I again redraw a picture of judicial review, you can imagine that if this is our Constitution of India, the highest law, there are a number of laws which emerge from this Constitution, a number of laws which emerge from this Constitution. Because the Parliament has the power to make all these laws. But all these laws, orders, regulations, policies, ordinances, resolutions, proclamations, they all have to be according to the Constitution of India. If not, they can be challenged in the court, and the court can declare them as null and void, as ultra vires, as unconstitutional, and they cannot come into force. This power of judiciary is called as judicial review. Now, please note that the concept of judicial review is of American origin, and in Indian Constitution, it is not explicitly mentioned. We will see details about this power later in the next slide. Now, coming to the concept of judicial review in the Indian Constitution, as I mentioned, that the concept of judicial review is not explicitly mentioned in the Constitution. This power can be derived. It can be derived from Articles 32 and Article 226. I'm sure you people understand that we have a three-tier judicial system in our country. We have subordinate courts, then we have 25 high courts in India, and then we have one Supreme Court. Subordinate courts. So please understand and remember that the power of judicial review is implicit, is implied for Supreme Court under Article 32 and for High Courts under Article 226. Therefore, the power of judicial review is not available to subordinate courts in India. A subordinate court cannot declare a law of parliament or a law of any state legislature as unconstitutional. Only Supreme Court and High Courts have that power. So one thing that you have to take home today is that the concept of judicial review is implicit in Articles 32 and 226. Having said that, let me here mention a very important point about fundamental rights. We all know that in our Constitution, originally we had 22 parts, and at present we have 25 parts of Constitution. Out of these parts, the part number 3rd from Articles 12 to Article 35 deals with the fundamental rights. In these articles, we have Article 13 Clause 2. And the Article 13 Clause 2, it says, the state shall not make any law which takes away or abridges any right given in Part 3rd. And if any law is made against this provision, contravening this provision, that law shall be void to the extent of contravention. Let us have a look at the article. It says, the state shall not make any law which takes away or abridges the rights conferred by this part. This part means Part 3rd, fundamental rights. And any law made in contravention of this clause to the extent of contravention be void. That means regarding fundamental rights, the constitution makers have explicitly given the power to the courts to declare a law as void if that law violates the fundamental rights. So let us say tomorrow Parliament makes a law and that is an ordinary law. An ordinary law. And in this law, there is a section, there is a part which is violating the fundamental rights of citizens of India. And now the judiciary, Supreme Court or High Courts can use Article 13 Clause 2 and declare that part in that law as null and void on the ground that it is violating the fundamental rights in Part 3rd. So Article 13 Clause 2 explicitly empowers the judiciary to declare a law as void if it violates the fundamental rights. So remember, only for fundamental rights, the power of judicial review is explicit in the Constitution. For rest of the provisions of Constitution, the power of judicial review is implicit in Article 32 and Article 226. I hope the concept is clear so far. Now, whenever the judiciary exercises the power of judicial review, it uses some principles, it uses some concepts, some doctrines. Let us have a look at these concepts. Now, within the concept of judicial review, each of these doctrines is individually also important. The first one is presumption in favor of constitutionality of law. What does it mean? We understand that in a democracy, in a democratic country, laws are made by legislatures, and these legislatures represent the people of that country. In our case, it is the parliament at national level, union level, and state legislatures at the level of states. At the union level, the parliament represents the people of India. Parliament has been given the power by Indian Constitution to legislate laws on the subjects of union list and concurrent list as given in the 7th schedule of the Constitution. Because the parliament represents the people, we must have faith in our parliament. We must have faith in the people's elected representatives. And therefore, when people's representatives make a law, we have to presume that they do not have any malicious intention, any deliberate wrong intention. We presume that the law made by people's representatives is for the people and is according to the provisions of the Constitution. So we always presume that the law is constitutional unless it can be proven in the court that the parliament has made a law which is definitely against the Constitution. To understand this concept, you can relate it with the concept in our judicial system, in our criminal justice system, that every accused person is presumed to be innocent until proven guilty. So even if there is a person who is accused of whatever crime, unless those charges have been proven in a court of law, even during trial, we presume that the person is innocent. So presumption is in favor of innocence. Same way, whenever the legislature made a law, we presume that the law is constitutional. This ensures that the judiciary does not overuse the power of judicial review and declare laws as null and void. The second concept is doctrine of liberal interpretation or doctrine of progressive interpretation. Now, as per this doctrine, whenever any law is challenged in the court for its constitutionality, the judiciary has to give that law and constitution a liberal interpretation, an interpretation which is according to the changing social and economic circumstances. The interpretation cannot be rooted in the history. It has to be done taking into account the present circumstances. For example, Indian Penal Code, the main criminal law of India, has section 377, according to which homosexuality was a criminal offense. Was a criminal offense. The section used to provide punishment for any unnatural sexual activity. Now, at one point of time, homosexuality was considered as an aberration, as a disease, and as an unnatural act. But with time, it was believed that there is nothing unnatural in homosexuality. And that is when, keeping in mind the progressive interpretation and the advances made in the society, the Supreme Court declared this section as unconstitutional because this section was violating the fundamental rights of the LGBTQ community: lesbians, gays, bisexuals, transgenders, and queers. So, the Section 377 was drafted in times when homosexuality was considered as unnatural, as an offense, and such persons should be punished. With time, as society progressed, society became more liberal. We recognized the rights, the freedoms of every person, including the LGBTQ community. And thus, eventually, Supreme Court in 2018, by a bench led by former CJI Deepak Misra, declared this section as unconstitutional. Now, this is the concept of doctrine of liberal interpretation or progressive interpretation. The third concept which judiciary uses is the doctrine of severability. This doctrine means that whenever judicial review is applied by judiciary over a law, what is the possibility, a greater possibility, that not the entire law, but a part of that law, a subsection of that law only violates the constitution. For example, if this is our constitution and this is a law which is challenged in the court, what is possible that in this law there is a section and only this section is violating something in the Constitution of India. So while judiciary applies judicial review on this law, not the entire law, but only this section or part of that section which is against the Constitution, only that part is declared as unconstitutional. For example, Section 66A of the Information Technology Act 2000. Now, this section was said to be misused to prevent people from exercising their freedom of speech and expression, which is a fundamental right under Article 19(1)(a). So, when this section was challenged in the court did not strike down the entire IT Act, but only Section 66A as null and void. This is the concept of doctrine of severability. So only those parts of law become void which are against the Constitution and not the entire law. The fourth concept is the concept of due process of law and procedure established by law. This concept of procedure established by law is given in Indian Constitution in Article 21, whereas this concept is given in American Constitution. American Constitution. Under procedure established by law, the judiciary only examines that whether a law made by legislature has been made by following the proper legislative procedure. Does the legislature have the competence to make a law on that matter? And whether the due procedure has been followed while making that law. The judiciary does not examine the inherent goodness of law. That whether the law, which is under review of judiciary, what is its inherent goodness? Inherent goodness. That is the law fair? Is the law democratic? Is the law reasonable? Or is the law unfair, unreasonable, undemocratic, whimsical, and fanciful? That means judiciary does not check the spirit, the intent of the parliament in making that law. Whereas, under due process of law, the judiciary goes a step further. It not only checks that the law has been made by following proper procedure, given the laid down procedure of lawmaking, it further checks that is the law reasonable? Is the law democratic? Is the law just? Or is it unreasonable and unjust and undemocratic? And therefore, the countries where we have due process of law, like in America, the judiciary is more powerful. The power of judicial review is stronger in the countries where we have the concept of due process of law. In India, although in Constitution, in Article 21, we have procedures established by law, but Supreme Court, in a landmark case called Menaka Gandhi, Menaka Gandhi versus Union of India, 1978, Supreme Court held that the Indian Constitution has the concept of due process of law within the principles of natural justice. These principles of natural justice are inherent in every democratic constitution. And within these principles, we have the concept of due process of law. Therefore, the judiciary has read this concept of due process of law in the Indian Constitution. The next concept is doctrine of prospective overruling. The doctrine of prospective overruling means that whenever a law is struck down as void, as ultra vires by constitution, I beg your pardon, by judiciary, the law becomes inoperative from the day on which it is declared as void by the judiciary. That means before the law is declared as void by judiciary, all the actions done under the law, they remain legally valid. From the day on which a law, an order, or a policy is declared as unconstitutional, from that day onwards, it becomes inoperative. So therefore, it is doctrine of prospective, which means from now onwards and not from a back date. It is called prospective overruling. For example, let us say this is our constitution, and I gave an example of section 66A of the IT Act. So on the day Supreme Court declared this section as unconstitutional, it becomes inoperative. But under this section, there might have been certain cases where people were imprisoned. They were even convicted under this section. So those actions remain legally valid. So this is the concept of doctrine of prospective overruling. Okay. Let us have a brief look at the history of judicial review. As I mentioned, that the concept is of American origin. It is of USA origin. However, it is again not given in the American Constitution, but has been a discovery of the American Supreme Court. The first case which happened in American Supreme Court, US Federal Supreme Court, regarding judicial review was Hilton versus US 1796. In this case, the petitioner challenged a law made by US Congress, the US Federal Legislature, called as Carriage Act. Carriage Act. This Carriage Act made by US Congress was imposing a new tax called as carriage tax. So the petitioner argued that the act itself made by the Congress is against the US Constitution and therefore the act should be unconstitutional. So this was the first case in which the American Supreme Court started applying the concept of judicial review. And finally, this concept was established without doubt in a very famous case called as Marbury versus Madison, 1803. In this case, American Supreme Court, Federal Supreme Court, recognized that the American judiciary has the power of judicial review. The Chief Justice Marshall of American Supreme Court said that the judges of judiciary take an oath under under Article 6 of US Constitution. And this oath is to defend and uphold the Constitution, the US Constitution. And therefore, as part of this oath, as part of their duty, they will prevent enactment of any law which is against the American Constitution. Thus, this case established the concept of judicial review in the American legal political system. I hope the concept is getting clear in your mind. Coming to the second concept for the day, which is judicial activism, which is sometimes also called as judicial overreach. Judicial overreach, or it can be called judicial transgression. Judicial transgression. Okay. If I explain this concept in one simple line, it is when judiciary performs certain actions which cannot be called as actions of judiciary because those actions fall in the domain of either legislature or the executive. We understand that we have a concept of separation of powers, under which the three organs of state, the legislature, the executive, and the judiciary, they have been assigned specific functions. Whenever judiciary engages into the functions which are to be performed by executive or legislature, we generally call those actions by judiciary as judicial activism. Now, this term judicial activism is difficult to be defined because for some people, an action by judiciary can be acceptable and very much a part of Supreme Court's duty. But for others, the same action may be an action of judicial activism or judicial overreach. So let us see that what actions of judiciary are deemed as judicial activism. That means when these actions are performed by judiciary, you can call them as act of judicial activism. The first one, as I explained, is when the judiciary enters the domain of legislature or executive. Now, legislature we know has the domain of lawmaking, legislature, whereas executive has to do with execution of laws and formulation of policies. So if the judiciary starts making laws via judicial legislation or starts interfering in the policies of executive, those actions are considered as judicial activism. Second, departure from departure from established precedents. Departure from established precedents. Now, what does it mean? Our judicial system functions on the basis of a principle, and that principle is called as stare decisis. It means that when a higher court gives an order in a particular case, in a similar case in future, the order has to be same. There has to be a synergy in the orders of the judiciary in similar cases, in similar circumstances. This is called the concept of stare decisis. It seems to be fair because if there is a case involving similar matter where judiciary gives a different judgment, a different interpretation, and in some other case on same issue, similar matter, judiciary gives a totally different order or a totally different interpretation, that would lead to a lot of uncertainty. And therefore, the judiciary follows the principle of stare decisis. That means principle of following the precedents. But if the judiciary starts deviating from these precedents with unreasonable justification, that can be called as the departure from established precedents, and that can be called as judicial activism. Third action of judicial activism is when judges allow their personal opinion to influence their orders. Let me write here. Judges allow their personal views to influence their judgments, or when judges start engaging, when judges engage in populism, in populism. Populism means to appease the people, to make the people happy. The judiciary cannot start delivering verdicts to make the people happy. Judiciary has to work according to the law, what is written in the books of law. And when judges try to appease the people, they allow their emotions to come in the way of their work, or they play to the media. They play to the media. Then also we call it as an act of judicial activism. So these are the three main actions which, if performed by judiciary, are deemed as judicial activism. The opposite concept of judicial activism is called judicial restraint. Restraint means when the Supreme Court is conservative in defining its own powers. It performs only those functions which have been assigned to it by the Constitution of India. It gives a conservative interpretation to its own powers. It is called judicial restraint. Whereas when judiciary gives liberal meaning, liberal interpretation to the Constitution as well as to its own powers, it becomes judicial activism. Now, what causes judicial activism? What are the causes for judiciary to get activist? The first reason can be legislative vacuum. Legislative vacuum. Legislative vacuum means we understand that lawmaking, legislation, is the job of legislature, the parliament or the state legislature. But if the parliament, for whatever reason, has not enacted a law on a specific sphere, specific matter, and the matter reaches the court may feel compelled to enact a law on that matter. For example, in this we can give example of Vishakha guidelines. Vishakha guidelines, 1997. A brief background of these guidelines. In 1992, there was a woman called Bhamri Devi, and she was working as a social worker under Rajasthan state government. Rajasthan state government in 1992 launched a program where these social workers were given the job of creating awareness in villages about child marriages and prevent child marriages in villages of Rajasthan, which was quite prevalent in those times in Rajasthan. So Bhavari Devi was one of those social workers, as she was called, they were called as Sathin. And as part of her duty, she was trying to prevent child marriages in the villages. One unfortunate day, she prevented a marriage of 1 year old girl, child marriage. Now, this made the villagers angry, and five villagers gang raped Bhamri Devi in front of her husband. To utter surprise, the lower court acquitted all the five accused. Finally, five NGOs by the name Vishakha appealed Supreme Court and filed a public interest litigation. Till that time, the parliament had not enacted any law for the prevention of sexual harassment of women at workplace. That means there was a legislative vacuum. There was lack of law on the subject of prevention of sexual harassment of women at workplace. So finally, Supreme Court felt compelled to fill that vacuum, to fill that void by making a law. And that law was famously called as Vishaka Guidelines. In this law, in Vishaka Guidelines, Supreme Court not only gave a comprehensive definition of sexual harassment at workplace, it also put onus, responsibility over the employer to ensure that at workplace, women are not sexually harassed. Now, these guidelines were replaced by a law of parliament after many years by a law called as Prevention of Sexual Harassment of Women at Workplace, which is famously called as POSH Act 2013. So, in the absence of such a law, the court felt compelled to fill that vacuum, and this is called as judicial activism. The second reason is because something similar but different, that what if there is a lack of action by legislature because of hung assembly. So let me write here, uh, weak legislature due to hung assembly. That means if there is hung assembly, the government is either a minority government or it is a coalition government. In both cases, the government is surviving with the support of, with the help of other political parties. And therefore, in such circumstances, the government may not be able to introduce certain bold but necessary legislations, and the parliament, the legislature, becomes weak. In such circumstances, if legislature is not making necessary legislations, the court may be compelled to come forward and fill that vacuum because of weak legislature. The third cause of judicial activism is executive apathy. Is executive apathy. That means if the executive has become insensitive and is not taking certain actions, the judiciary again might come forward and give directions to the executive. A perfect example of this is what we have seen, that the high courts and Supreme Court have come forward in giving directions to the executive to have a national plan to deal with COVID-19 crisis, the second wave of COVID-19 crisis, which has hit India very badly. Not only that, the court also directed the central government to ensure the supply of oxygen to states, especially to the Delhi government. The Supreme Court required the center to provide vaccines to all, and that too for free. So all these actions which Supreme Court is directing to the executive can be deemed as judicial activism. The fourth point when judiciary intervenes is when fundamental rights of citizens violated are violated. So this is also a moment for judiciary when it comes forward, becomes activist, dons its activist avatar, and issues instructions to protect and to act as the guardian of fundamental rights of citizens of India. Coming to the apprehensions because of judicial overreach or judicial activism. That means if judiciary is engaging in judicial activism or judicial overreach, what can be its long-term undesirable consequences? The first consequence is it disturbs the balance of powers. The balance of powers among three organs. So we understand that our constitution provides for a concept of separation of powers where every organ, legislature, executive and judiciary, has dedicated responsibility and function. If judiciary starts entering into those functions which are reserved for other two organs, it will disturb the balance of powers. The second effect of judicial activism is that judicial activism might not take into account the administrative problems and difficulties because judges are legal experts. They may not have competence and experience in administrative matters. As a result of this, sometimes their orders can be more emotional rather than practically and administratively feasible. So let me write here. Impractical orders. Impractical orders. Third point. Third point is if judiciary starts intervening in the policy matters, which is an executive job, it can also lead to a kind of apathy on the part of executive. That means executive will start waiting for judicial directions rather than proactively making policies. Fourth undesirable consequence can be that our judiciary, all the three levels of judiciary, are already having a lot of backlog of cases. So if judiciary takes up the cases of judicial activism rather than disposing of the regular pending cases, it will further complicate and further delay the working of the judiciary. So, judicial activism at the cost of at the cost of pending cases, at the cost of pending cases, which is not good. And lastly, we can say that the judges are appointed and not elected, and therefore lawmaking or policy making is not their mandate. And in long term, it can disturb the balance of powers amongst the three organs. This is the concept of judicial activism and judicial overreach. I hope that I have made the concepts clear. I hope you can now differentiate that what is judicial activism, judicial overreach, and judicial review. This concept is important, as I mentioned earlier in the class, is not only for prelims, but also for main, not only for general studies, but also for the optional paper of public administration. Thank you and take care of yourself and your families.